What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Tuesday, February 18th. We were back in court today, and it was also the first day of the defense case, although not a lot of testimony, at least on the live stream. We're going to get into what happened. Before we get started, if you're watching on YouTube, don't forget to hit subscribe, like the video, share it with your friends, and you can click that little bell icon if you want updates of when I post new content. So I'd heard some rumblings that there was a chance that John Mello and Christina Parcells' daughter, who is around the age of 13 now, might take the stand in Zack's defense. And that would have been the case if the judge would have allowed the defense that Zack was going for to come in. He was looking to put up a defense of others case. What is that? It is the defense to liability for an alleged crime that is in defense of a person other than oneself. In other words, Zack admitted to killing Christina Parcells. The jury heard this today. And the reason that he was going to put forth is because of the concerns that the child was in imminent danger of being abused. So let's look at the argument that happened outside the presence of the jury and not on the live stream about whether or not to allow Zack to get on the stand and use this defense. The defense says that they're entitled to pursue a defense of others case. If the person who was being protected had a right to self-defense, the person who acted had a right of self-defense. There are elements of self-defense. The child must be without fault, and the defense says she was victimized through no fault of her own. Both Christina and Brad abused her over multiple years. The one thing that the state and the judge both agreed on is that the child wasn't in imminent danger because she was at school at the time her mom was killed. So the defense says, are we saying the child had to get home and wait to be victimized? No, she was in imminent danger of being abused. The abuse was so bad, and the family court believed the child was in imminent danger. The duty of retreat does not apply to Zack. He stands in the child's shoes. The judge goes back in chambers for a bit, comes out and says that this defense is not allowed. He says that the defendant traveled to the house, sought Christina out to murder her, and you can't escape criminal liability. Zack unlawfully entered the house and used the defense of others as a shield to his actions. The defense also wanted to argue the malice without just cause. They believe it's admissible for them to argue to show that Zack did not have, as the state said in their opening arguments, an angry heart. He went in there with no malice but to protect the child. None of that coming in. And we got to the defense openings. The defense says Zack's been waiting over 3 years for this. He's a gifted and accomplished young man. He was 29 when this happened, and he's 32 now. He was born in California, and his parents took their kids and moved to southwestern Virginia to a small farm and adopted 5 orphaned children. Zack was homeschooled. His family moved to Greenville when Zack was a teenager. He was accepted into college on scholarships and won piano competitions. As an adult, he's had an accomplished career performing. They say we have no obligation to be doing this. This could all be over because the state has the burden of proof. But Zack will take the stand and tell you why he killed Christina. We could attack the testimony of the neighbor. After 3 years, she was able to identify him after his photo had been on television for 3 years. The person on the bike wasn't in the neighborhood for an hour and 15 minutes after she said she saw him. We could have objected, pressed the witness. Why didn't we? Because Zack will take the stand and tell you why. You're going to hear the why, which was not jealousy or greed or a crime of passion. He didn't act with an angry heart like the state says. This wasn't done for money. This was done for a just cause. That's not malice, and that's not murder. The first witness that they call was actually a state's witness that testified last week, Investigator Bevill. They ask him, when you work in the Crimes Against Children unit, do you get special training? Yes. They show him the report he drafted in the harassment case with the nude photos that were circulated. They ask about lead investigators and say they are ultimately responsible for the investigation, and the witness says yes. On October 19th of 2021, did you become the lead investigator in another case? There's an objection that's sustained. Of course, they're talking about what was found on Bradley Post's devices after Christina's murder. There was some back and forth here for quite a bit about some wording in his report. Really, I think the defense got a little bit confused, and it was the poor wording which the witness admitted to. In one part of the report, he talks about photos being seen that were color and not black and white. The defense thought he was talking about the website that was testified to last week that he went to that was not working, but directed him to another escort website. The defense thought he meant he saw photos on the website of Christina, but he was talking about the ones in the envelope. And it was back and forth for a bit. At one point, the jury was sent out, and the state says the defense has called this witness to impeach his prior testimony, and that's improper. They had the chance to cross-examine him. But the defense says the parties agreed we could recall witnesses who are under subpoena. The judge allowed the defense to continue questioning the witness. But in a nutshell, it was just a little bit of poor wording in the report on the investigator's part that was misunderstood by the defense. They thought he saw photos on a website. He was referring to the ones in the envelopes, and that was it. The witness leaves, and the defense still wants to proffer questions they didn't get to ask the witness. They ask if he's already left. He did walk out. At one point, he did come back in, but what the judge has the defense do over probably the next hour is essentially give a summary of the questions they would have asked witnesses that now will not be allowed to testify for the defense due to the judge's ruling about the defense of others, as well as just the child abuse materials in general. So let's get down to what the defense would have asked this witness had that defense been allowed, had Christina's daughter taken the stand and likely introduced what happened to her. He would have asked if he was the lead investigator in the child abuse materials. And on October 19th of 2021, the witness was made aware there was child abuse materials on a phone belonging to Bradley Post. After the investigator was made aware, he went to verify the images, and immediately after seeing them, he obtained an arrest warrant for Bradley Post for exploitation of a minor. He called another officer to respond to the Canebrake address to wake the child to put her into emergency protective custody. They talk about the photo that was the basis for that warrant, and after seeing the images, he knew the child had been exposed to abuse and would ask him on October 19th if he dispatched the Facet Unit for apprehension of Post, where they went to his residence. And when they got there, they found a guest bedroom with a dollhouse, a pink alarm clock on the bedside table, and found other devices that contained child abuse material. What is Facet? It's a specialized warrant apprehension unit. They track down suspects wanted for recently committed serious violent crimes. The investigator determined there may be one other victim. I would ask the images he reviewed contained the child and her mother, Christina. In the investigation of Post and Parcell, he listed the dates of the abuse from January 1st, 2018 through October 19th of 2021. On October 20th, the investigator spoke to the other minor child's parents and got 5 more warrants on the 20th. He said the images would have deemed this as a violent crime. They go through the devices telling some of the details of what was seen. I will not recap that part. You don't want to know. It's just disturbing stuff, as you could imagine. Based on this review of what he saw Christina doing, they obtained a warrant for criminal sexual conduct in the 3rd degree against Post, and that is a violent crime. He would testify he got another warrant for Post on January 10th of 2022 for buggery, which in South Carolina, that means it has to do with animals. He investigated Christina and Post previously on molestation allegations from John Mello back in 2018. After Mello made a report, he was worried Post was abusing his daughter. On March 16th, 2018, the investigator sent John Mello an email. And in the email, he told John, as of today, this case is officially closed and that he couldn't establish probable cause that any abuse had occurred. I would have asked the periods he testified the abuse was happening. He wrote Mello an email closing a case saying he couldn't find any abuse. The next witness that they would have called, and they did not, this was another summary of what they would have asked, is the owner of a cigar bar here in Greenville that Bradley Post went to a lot. After Bradley Post's arrest, this witness found more electronics containing child abuse materials. Post had a locker at that cigar bar, and the witness would say he saw there were multiple external hard drives and thumb drives in the locker. Knowing why Post had been arrested, this witness contacted law enforcement who responded and seized the devices. Another witness who is in law enforcement would have testified they executed a search warrant in the locker and seized those devices, took them to the law enforcement center, and the most pertinent devices had multiple files of Christina participating in child abuse material. The next witness they would have called, some of these names may not be 100% accurate. I can't go back and watch on the feed, and I'm in the way back, and sometimes it's hard to hear. I think it is Vanessa Carmala. She owns her own law practice and does family court work mostly. October 2020 through August of 2023, she was the guardian ad litem for the child, and this was a case that Christina initiated after John took their daughter to Italy. She would testify she knows about the litigation between the two, meaning the 3 prior cases between them, and would testify that she wondered why Christina would give up custody to John Mello. She would testify her impressions of Christina. Christina told her she was an open book. Her impressions of Bradley Post were creep factor and that he was gross. She would testify that Bradley Post would not agree to meet with her, and she thought that Bradley Post was bankrolling some of the litigation in family court. John Mello had told her that Christina had been a prostitute and sold drugs. They said that the testimony would have also included the witness's knowledge of a deposition in which Parcell said she took part in a pornographic film. The witness spoke to Alex Fields, a firefighter who is now deceased. Alex told the witness he ran into Christina at Hall's Chop House restaurant and she propositioned him for sex and drugs. He said he declined. As far as the mailers that had the nude photos, the witness got a few. After Christina was murdered, she put the child with Christina's sister. Investigator Bevill made contact after he found the photos on Bradley Post's devices, and the witness went to the law enforcement center to meet with him, where they viewed the images, and the witness would have explained the horror of viewing those images of Christina and her daughter. She would say that she knew Investigator Bevill put the child in emergency custody, waking her up at 10 p.m., and removed her from the house. She would tell whose custody the child was placed in. Christina has never had custody. In the end, she went back with John Mello. If she had found those images before Christina's murder, she would have had the child removed immediately. The next witness is an investigator. One thing that I didn't explain earlier, and I don't want to start over, is that why are they putting this stuff out there now if the witnesses can't testify and the jury can't hear it? They are putting this on the record. The next witness was an investigator, Arnett, and they proffer what he would have testified to. He examined devices, seized and received Post's cell phone first, where he did an extraction and analyzed the data. He would have talked about his findings, and also he had been given other devices, a hard drive from a laptop and multiple thumb drives. He found thousands of files of child abuse materials. On one phone, there were 2,267 photos. Most were with the child alone or with her mother. On a hard drive, there were many photos of Christina and her daughter. One of the hard drives had 4,000 images and 48 videos. On another thumb drive, they found over 2,000 images and 137 videos of child abuse material. Another device, 1,500 images, 81 videos. On another thumb drive, 3,700 images and 47 videos. On another device, 1,826 images. Another thumb drive, 2,400 images and 136 videos. Another device, 184 images, and another device showed 36 images and 4 videos. Y'all, this was so hard to hear. The defense said they would have shown the investigator the sanitized photo and asked him to identify the child and Christina. They would have showed the photo from the phone of Christina and the child, and also an older male with shorter gray hair. They go on to describe what was in the image. I'm not going to put it out there out of respect for this young lady, as well as anybody who may be triggered by this kind of stuff. Eventually, the witness stopped searching the devices because they had so many photos and videos. There could have been hundreds or thousands more, but they had more than enough to prove their case. OneDrive, there was an error with that drive, so they don't know how many photos or videos might have been on that. They would have asked the witness about making copies of all the electronics for the defendant's investigator to go over. Another witness is an investigator for the defense team. He examined the devices at the sheriff's office due to the nature of the type of material. He would have testified how the child was depicted. In one, there was a third person shown, an older male. Organization of the files were very well organized. There was a top level folder, and underneath that were subfolders with names that would clearly tell you what kind of child abuse materials was contained in those. He went through specific devices like the iPhone and pulled up 20 different photographs. He would describe them to the jury in lieu of the videos and photos being put into evidence. At this point, the judge would not allow the defense attorney to describe the images and says that he is protected on the record. But the defense says it's crucial for these descriptions to go on the record due to the extent of the harm being inflicted on the child. The state says there's no evidence that Zack knew about the photos at the time of the murder. The next witness was Dr. David Corwin. He's a child psychiatrist from Utah. He specializes in child abuse of that nature. To sum up his testimony very quickly, the abuse is toxic, obviously, to the child on many levels, and it can be even worse with the frequency of the abuse. He goes on to say in the last 20 years, they have learned that this type of repeated trauma to children can actually change DNA. It can cause children to age faster, and all of the physical and psychological effects of child abuse of that nature. One of the last things that the state asked the witness on cross, how much are they paying you an hour? The witness said he couldn't afford his services himself, but they're paying $700 an hour for his services. And when asked, how many hours have you put in? The witness couldn't estimate. After all of this proffering was done, Zachary Hughes stands up. The judge advises him of his Fifth Amendment right, asks if he has discussed with his attorneys and friends and family whether or not he wants to take the stand. I wasn't sure, since that defense wasn't going to be allowed in, as well as the child abuse materials, whether or not he would take the stand, but he stood up and said he will take the stand. I believe that could be tomorrow. So we'll see what happens. That was it today. I know it was sort of a frustrating day for everybody watching the feed, but with the judge's ruling that we are on a 30-minute delay and arguments heard outside the presence of the jury can't be live streamed, there was very little streamed to you guys today, but tomorrow should be very, very interesting. I'm curious to see what Zack has to say on the stand. I will be live streaming in the morning beginning at 10 a.m., hopefully, unless there's any arguments before we get started. And then, as always, tomorrow night, I'll recap in an hour or less the best of the testimony so you guys that can't watch can stay current. All right, that's it for tonight. Hope you guys have a good rest of your evening. We will see you soon.